leave, already packing. Come with me, I'm not really asking. We'll get away to a place where we don't know. About to see the world in action, what we can be, life with no distractions. We'll get away, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out, die with my own doubts. Be free with me. Let's go, let's be free with me. Be free. Not looking back, eyes on the freeway, Bonnie and Clyde, a classic cliche. We're on the run, this is what we waited for. Take my hand, we'll make it somehow. We can't miss out. I'm done living life with the lights out, die with my own doubts. Be free. Let's go,
Evening everyone, Jim here at Tutor2. Welcome to the latest in our A-Level Law live streams. A chance to spend 25-30 minutes or so revising some specific topics through a mixture of activities, but also we'll go through some of the key content, perhaps some of the key cases or the key statutes or whatever, depending on the topic. Today's topic, I think we return, if I'm not mistaken, Sarah and Dan. Sarah in the middle, obviously, and Dan on the right. I believe it's tort. And thank you very much. That's as far as I know, but it's vicarious liability, and so I'll let Sarah or Dan introduce that topic in a second. For those of you joining us live for the first time, please get involved. Use the live chat to type in your responses to some of the questions and the activities. You don't have to, but it's great if you do. Looking at the screen here, we've got lots of people joining us live, but we know that many more people join us on catch up and replay when they're watching the video session. So for you, no live chat option, but there is an option maybe to pause the video, spend a bit more time on each activity, and then start the video again to see how you get on. Right, who wants to lead us off on this session? Who is it tonight?
I'll make a start. Well, it's both of us tonight, but I'll make a start on the first part. So this session, as Jim's already said, is on vicarious liability. So we find that in the area of tort law on paper 2. And tonight we've got around 30 minutes of quite a jam-packed session with some explanations, some exam gold included, and lots of fun quizzes, activities to play along with too. So as Jim said, please play along, pop your comments in the chat. And if you are watching at home, feel free to play along on replay too.
That reminds me, actually, Sarah, obviously, as we go through things like the exam gold, don't worry about writing everything down. At the end of the session, we'll post a link in the comments box to where you can download all the slides if you wish, and therefore potentially print them off or add them to your notes. So, as you say, it's quite fast-paced, so enjoy.
Okay, to start off with then, we're going to start with a thinking activity. So what is vicarious liability? And secondly, why does it exist? So if you want to pop your comments into the chat, what do we already know about vicarious liability? Who does it concern? And why do we have it? And then if we just pop our thoughts in the chat. Who specifically might want to claim this area of tort? And who are we claiming against? Fab. So we've got a couple of comments coming in now, which is great. If you're still typing, just send them into the chat. I can see Jim from 2 is also having a little bit of a play along, which is great. Claiming against an employer, Jim, that would be correct. So it's about finding one party, who's usually an employer, liable for the torts of another party, who is usually their employee. So historically, it was very much an employer-employee type relationship. It has been widened a little bit in recent days, which is why now it's easier to refer to it as one party against another. The person who commits the tort, in this case, we call the tortfeasor. They're not necessarily the defendant in this case, because we would usually claim against their employer. So if we mention the tortfeasor, that's the person who's actually committed the tort. There's a number of reasons why we might need vicarious liability. Often employers will have control over their employees, and so you may think that it's fair, just and reasonable to hold the employer liable rather than the employees. Employers often have deeper pockets, and you can see on that third bullet point there that employers will often also have liability insurances in place, so it's often fairer to seek compensation from the employers. Equally, employers are responsible for their employees and ultimately for training them as well. So anything that the employee is doing as part of their job, employers should take some responsibility over. Fab. Next slide, please, Jim. Okay, so just a little bit of background then for the test for vicarious liability. There's a 3-part test here. The first part is that a tort is committed. Vicarious liability falls within the area of tort, so there needs to be a tort committed. And remember that tortfeasor isn't the person who we're necessarily claiming against, but they do usually have some connection to the employer. Secondly, the tortfeasor must be an employee or in a position akin to employment. What we mean by akin is in a similar type employment situation. In present day, there is some situations where it's not a typical employee-employer situation. It might be voluntary, for instance, work experience, those kind of roles. And so we would look at whether we can find an employment situation through an akin to employment. And then thirdly, there must be a sufficiently close connection between the employment and between the employee's conduct, so therefore the tort. What the employee is doing, is it connected to the employment? Is it classed as in the course of employment? Or is it something that we would regard outside and therefore the employer shouldn't be liable? Next slide, please, Jim. We mentioned this earlier, but a little bit of exam gold here. In an application question, you don't necessarily need to spend a lot of time or consider a full analysis on the first part. So usually it's quite obvious that a tort's being committed. And so where we should spend most of our time is on the second 2 parts of the test, the latter 2 criteria. So first of all, is it an employment situation or an akin to employment? And is it something that would be classed as closely connected? So we're going to start off by looking at those latter 2 criteria. And we're going to start off with a game here. So again, feel free to pop in the chat and play along. We're going to look at these statements that are currently on the screen and decide whether we think that the tortfeasor is an employee if these situations would arise. Often we see some of these key things in scenarios that might indicate that it is an employee-employer situation, or again, that it's akin to employment situation. So if we use the chat here and you can just identify the statement by its number, which ones do we think would suggest that it's an employee-employer type situation? So we need to include in the chat the numbers here. Which numbers, which boxes would suggest that this is a relationship that is an employee-employer or akin to employment? So a great start there. So we've got a number 3 being mentioned, using the employer's tools and equipment. What else do we think? Any others? There's 16 in total, so there'll be a few more in there. Think about who is paying the employer or employee. Good answer there from Chloe as well. We've got about reporting to a manager. That could be quite important to determine whether we think that person is an employee, as opposed to the opposite, which would mean that the person's self-employed or an independent contractor. If the person's self-employed or an independent contractor, they cannot claim vicarious liability against the employer. Lily also popping in number 1 there, so picking up on how they're paid. Being paid a salary may suggest that the person is employed rather than self-employed. Fab, another one there, number 12, working solely for the business. That sounds like an employee, correct? That would be something that would suggest employment rather than self-employed. Any others, guys? There's a couple more in there. Fab, Lily, another one in there. Thinking about that training again, which we mentioned earlier, didn't we, as why justification for why we would have vicarious liability, being trained by the business. Elizabeth as well, fab, excellent. A couple more coming in. Okay, Jim, do you want to reveal the answers and let's see if these ones are right? So the ones that are now highlighted in yellow would be statements that would suggest that the person would be an employee. So things like being paid a salary, using the employer's tools and equipment, which was mentioned in the chat, being trained by the business and having that continuing relationship. So not a sort of one-off project or a short time frame with the employer, but a continuing relationship would suggest employment. Having things like benefits, paid holidays, sick leave, etc. Working solely for the business as opposed to working for a number of different businesses. Often self-employed people such as tradesmen, like a plumber or an electrician, may work for a number of different businesses at one time. If the business determines the work that's performed, and that kind of links to the next one as well, of being reporting to a manager, so you have somebody who's indicating the work to you. Those other ones that are on there may suggest that the person is self-employed, an independent contractor, and therefore we couldn't claim against the employer for those. Fab, next slide please, Jim. So I've mentioned this part slightly already, but it is important that we can establish if the defendant is an employee. We can only claim vicarious liability for employees or those in positions of employment. There's a recent case of Barclays Bank, which you may have learnt on your course, where there was 126 claimants, all employees of Barclays Bank, who were looking to claim against Barclays Bank for a doctor who would perform some medical examinations on them as part of their employment. The issue with the doctor is that the doctor had committed some sexual assaults on some of the victims, many of the victims, and they were hoping that they could claim against Barclays Bank under the principle of vicarious liability. Initially, they did win their case, but as you can see there, the UK Supreme Court reversed the earlier decision and reinstated effectively that an independent contractor defence would apply for the doctor. There was a number of factors in that case, but some of the points that stick out from that case and some of the reasoning why the person was an independent contractor was looking at things like whether they worked solely. So that was picked up on the last activity. Did they work solely for the business? The doctor didn't work solely for Barclays Bank. The doctor worked for the NHS, private claimants, and also wrote many articles in medical review magazines. So he was quite a busy doctor. He didn't only work for Barclays Bank. In fact, the work for Barclays Bank was quite a small proportion of his work. He also had his own liability insurance, and he had quite a lot of autonomy over the decisions that he made, which cases he took on, and the nature of his work. So they did decide in that case that it was an independent contractor. So again, from that last activity, some of those key statements, if we can spot those in the scenario, they can help us determine if we think the person is employed or self-employed and thus independent contractor. Next slide, please, Jim. So the tests for establishing this have been developed over a number of years. We did have a number of conventional tests, which you may have learned on your course, looking at things like who controls the employee, which again, we looked at on that previous quiz. whether the employee is fully integrated into the business, works solely for that business, or works as an accessory to that business and actually works for a number of different businesses, which tradesmen, for instance, may do. And finally, the economic reality test, which looks at a number of factors, focusing quite a lot on how the person is paid, who pays the tax, who pays the national insurance, etc. And that can also help to determine whether the person would be an employee or not. More recently, we've had these new cases come forward which have tried to establish a similar sort of akin to employment situation. In the Christian Brothers case, they decided that you can actually have dual responsibility by more than one employer. And later in Cox, they confirmed this, and they confirmed that it isn't just employee-employer situations, but it is those that are similar. So in the Christian Brothers case, we had lay people who were volunteering at a residential school who had sexually abused some of the children there, and they were held to be in joint vicarious liability with the managers of the school. And in Cox, we had a prison situation where a prisoner had injured a chef in the kitchen, and they decided that the prisoner could be classed as akin to employment. So although you didn't have the traditional employee-employer contracts in place, there are lots of situations that can now be covered by these tests. And just remember that if an employer or an employee is considered an independent contractor, then they wouldn't be able to claim. Okay, next slide, Jim. From the Catholic Brothers case and what was recently or afterwards confirmed in Cox, there's 5 situations that merit the social justice behind this of finding the employer fair, just and reasonable. We've popped the middle 3 in bold because in Cox these 3 were given a little bit more weighting than the others. So again, in your scenarios, when you're answering your questions, if some of these situations are present, this again could suggest that it's fair to hold that employer responsible for that employee's actions, for the tortfeasor's actions. So things like the fact that the defendant is more likely to have the means of compensation, namely through insurance, that the tort had been committed as a result of activity that's been taken on behalf of the defendant, on behalf of the employer, that it's likely to be part of the employer's business activity and day-to-day role of that employee, that the defendant had created the risk of the tort being committed, namely by employing them or allowing them to work for them, and then finally the fact of the degree of control that the employer would have over the tortfeasor. Next slide, please, Jim. I'm going to hand over to Dan now for the second part of this session, where we're going to start with a big reveal of a case.
Thank you very much, Sarah. So, as Sarah just said, we're going to do a big reveal. If you've not done this with us before, then what we need to do is, as each slide is revealed, you need to try to guess the case name. Now, it's usually one which is linked to something we discussed recently. And so we're going to go over to the next page. So the first clue is that this case was heard in 2020. Now, if you do think you know the case, then pop it into the chat box. If you're coming at this from a different perspective, if it's not live, then please pause if you do remember and try to get that case down. Okay, the second clue then is that this concerned an employee that was employed as an auditor. So again, if you do know this case, please pop it in the chat box. The third clue is the employee who worked for Morrison's supermarket was disciplined and sacked. Okay, none coming in just yet. Okay, the fourth clue. He later published employee data on the internet that he stole whilst he was employed. Okay, so this is quite a recent case. Our fifth and final clue. Morrisons were not liable. Okay, the intentional tort was to deliberately harm the employer with no benefit to the employer or the employee, so it was not closely connected. And the case name is Morrison's Supermarket and various claimants. So, of course, this was heard by the Supreme Court. We can see various claimants there are the appellants. Okay, thank you, Jim. Next slide. So some exam goal then. So for the final part of this test, Sarah mentioned the previous test before, but for the final part of the test, you must identify from the scenario facts if the tortfeasor's conduct is sufficiently closely connected to the employment. This is what we're looking to prove. All of these rules and cases are how we identify this. Now, case law has established some situations where employers will and will not be liable, so you can use a precedent to support your answer. So what we're looking for here then is the close connection test. So this is to identify if the tortfeasor's actions were closely connected to the employment, and only in that case will the employer be liable. So there are broadly three ways in which actions can satisfy the close connection test. So firstly, we start with authorized acts. So this means if the employer has told the employee to do something specifically, or where the relationship is akin to employment and they've been told to do something, then of course this can be an authorized act. So look for example in Mattis and Pollock, in which a bouncer using force and injuring somebody was an authorized act, as they were encouraged to use violence or physical force to do the job. The second one, authorised acts done in a negligent or prohibited way. So that's broadly two different matters. So we might look at negligent acts, for example, in Century Insurance and Northern Ireland Road Transport Board, where the driver of a petrol tank negligently delivered, and he had a cigarette and threw the cigarette away. As he threw it, caused an explosion. That is clearly doing his job, but in a negligent way, and the vicarious liability was imposed on the employer in that case. In terms of a prohibited way, so this is acting against orders. So, for example, in Olympus and London General, the bus driver was told not to race other bus drivers while trying to collect passengers. They ignored the orders, but they still raced, and of course, somebody was injured and was able to claim against the bus omnibus company. Rose and Plenty again. So, in this particular case, the instructions were to not use child helpers on milk floats. Again, the tortfeasor disregarded the instructions and still used a boy to do that particular job, and he was injured. And again, the vicarious liability was imposed on the employer in this particular situation. Now, the final way is intentional tort or criminal acts which are closely connected. In this particular case, then, we have a particular criminal act. So in this case, was assault from the man who was employed at the defender's petrol station. He assaulted the customer and he caused him some injuries. Now, again, this is closely connected because he was doing his job at the time, and there was lack of control in terms of his actions. But of course, he was doing his job, and it was linked and closely connected. Now, these are policy-based decisions, and in all of these three cases, we have to look at other criminal cases as well too. For example, like Lister and Halsey Hall, where the warden of a school sexually abused children, again closely connected to the employment. And going back to that Mattis and Pollock case as well, again closely connected to the employment, so told to do a specific act. So like I say, in all those cases then we have control over the employee, and so therefore we have a close connection. Okay, next slide please, Jim. So there are particular situations which are laid out in case law when we look at whether it will not satisfy the close connection test. Now, broadly categorized, we have things which are unauthorized acts, acts which are taken outside the course of employment or a frolic of their own, and finally, intentional tort or criminal acts that are not closely connected. And we're going to look at a particular case again, Morrison's, for this one. So in this particular case, an unauthorized acts, this is where they've been forbidden to do something. So the employer says to the employee, you are not to do this. Now, one case example, is Beard and London General, so the same company as before. However, this one involved a bus conductor who was employed to collect the money and the fares, but actually he was not supposed to be driving. He decided to drive the bus, and as he did so, he injured somebody. Now, in this case, there was no vicarious liability because he was expressly told not to do this. Again, unauthorised acts linking Twine and Beans Express. Here the claimant's husband was killed through the negligence of a driver who was forbidden to give lifts. Now, there was signage on the vehicle and he was told not to do it. However, still gave a lift. The person who gave a lift was killed, and again, there was no vicarious liability because it was an unauthorised act. Now, going to the second point, the acts taken outside the employment remit or a frolic of their own. One key case is Hilton and Thomas Burton. In this case, the group of workmen took an unauthorised break and they went to a cafe. As they're coming back from the cafe, they were involved in an accident and one of the workmen was killed. And the employees in this particular case were held not to be liable because they were not on work time, and so therefore they were not doing the job at the time. It wasn't closely connected. And in the final case, in the final example, so intentional tort or criminal acts that are not closely connected. We looked at the case of Morrison's supermarket before.
Yeah, so in the Morrison's supermarket case, the one that was on the big reveal, they was looking at actions of an employee after they had left. So they'd actually been dismissed at this point. They had taken the data from Morrison's at the time. The data was regarding a number of employees. So the various claimants in this case are Morrison's supermarket employees. And they were concerned with the fact that their data had been shared online. The tortfeasor in this case was an auditor who had worked for Morrison's and taken the data whilst he worked there, but had spread it maliciously after he'd left as a sort of act of revenge and intentional tort against Morrison's. In that case, they decided that it was a criminal act that was not closely connected. So I think these are quite good cases to contrast. You mentioned the other Morrison's case with the petrol station employee. To contrast whether the person is actually closely connected in their work at the time, as they were in the latter Morrison's case with the employee at the petrol station who was actually at work at the time, but then also for the ones that are not closely connected. The Supreme Court also said that deliberate torts would usually not be closely connected where they've been deliberately set to harm the employer. And it comes back to the argument of what is fair, just and reasonable.
Indeed, thank you so much for that. The joys of teaching online. Right, so thank you. Next slide, please, Jim. So now what we're going to do is a true and false activity. Now, in this true and false activity, what you need to do is pop in the box whether you think it's true. Now, if you do have a little bit of time, obviously try to give some authority as well. If you're doing this at home, of course, try to give an authority. So what we look for is true, false, and a reason that is true or false. Usually in this case, and particularly with vicarious liability, we're looking for cases to support the answer. So our first one is that an employer can be vicariously liable for acts done by their employee in a prohibited or negligent way. So if you pop in the box whether you think that is true or whether that is false, and of course, if you're writing this down at home, then give yourself some time to write in the answer and write in a case. So is this true or false? An employer can be vicariously liable for acts done by their employee in a prohibited or negligent way. Okay, so we've got one answer going false. Okay, let's reveal the answer, please. That is, of course, true. Okay, so if we look at Century Insurance, a negligence act, so the cigarette causing an explosion but doing the job negligently. We have Limpus, thank you, Peter. Limpus and Rose and Plenty. So then, of course, the next question. The employer can be vicariously liable when employees do an action that is considered to be a frolic of their own. So is this true or is this false? So we did have Peter giving an answer before. Peter, do you think you might do this one again? So we've got Jim, a tutor to you, is doing false. Lily's gone false. Okay, let's reveal the answer. Right, both of you were correct. So thank you, Jim. Thank you, Peter. Thank you, Lily. Indeed, the employer can be vicariously liable. They cannot be vicariously liable. So when the employees do an action that is considered to be a frolic of their own, so an unauthorized break, for example, in Hilton. Okay, thank you, Jim. And well done in your answer. So employees can be liable for criminal acts of employees. Is this true or is this false? So definitely something we covered in this session. So pop your answer into the chat box, true or false. If you've got really fast typing, you can obviously try and put a case in as an example too. So it doesn't mean they always will, but they can. Okay, thank you, Peter. Can we reveal our answer? It is indeed true. Okay, so they can be liable for the criminal acts of employees. The 2016 Morrison's case, Mohammed and Morrison's, and Mattis and Pollock can both illustrate this point. In both cases, customers were assaulted and it was closely connected to the employment. Thank you, Jim. Next slide. Now, employees traveling home from work are typically classed as being in the course of employment. So again, is this true or is this false? You pop your answer into the box. When they're traveling from home, are they in the course of employment? Right, so Peter's coming with the answer being true. Can we please reveal the correct answer? It is false. Okay, so if you're traveling to or from work, you are not classed as being in the course of employment. It is, in a sense, your personal time. And this may change if, for example, you're traveling from one workplace to another, but it would require some insurance, some acknowledgement that that is the case. But traditionally, if you're traveling, you will not be considered in the course of employment, and any tort committed at that point will not be considered closely connected with the purpose of vicarious liability. Okay, next question. So employees taking unauthorized breaks are typically classed as acting in the course of employment. Again, is this true or is this false? So I know a few of you, Lily, Peter, Elizabeth, you've taken a guess at each of these ones. Could you try to get an answer in the box? And those at home who are doing this at a later date, of course, pause, see, and then before we reveal the correct answer. Okay, Jim at 2 has gone false. Lily's gone false. Peter's gone false. Okay, can reveal the correct answer. You were all correct. Well done. It is indeed, again, a frolic. And so they would not be considered closely connected to the tort and employment. Okay, thank you very much. Next question. Vicarious liability is contained in the Vicarious Liability Act. Is this true or is this false? So once again, nice and quick. True or false? And we will reveal the reasoning for the answer. Okay, Elizabeth's gone false. Jim has gone false. Okay, let's reveal our answer. It is indeed false. Okay. What you might have noticed is as we went through this PowerPoint and in your studies of vicarious liability, it is predominantly, indeed, all based on common law. So we're looking at judicial precedent, case law, not statute-based. Yes. Okay, thank you. And now on to the next activity. In this one, this looks a little bit like a newspaper headline with words blanked out. We're calling it a case judgment challenge. So what you have to do is fill in the missing words. Now, if you're doing this at home, you might choose to write it out and fill in the blanks. If you're online, you might type in the blanks into the comments box. So the text that we are assessing is this. The case of Barclays Bank PLC and various claimants held that the bank were blank because the doctor was classed as an blank. So what I'd like you to do is to fill in those blanks. So there are two phrases and I'd like you to fill in both of those. So you may choose to type it into the box and you may choose to write it down. It's entirely up to you, but you're just filling in those blanks. So the case of Barclays Bank and various claimants was held that the bank were not liable, like Lily says, because the doctor was classed as an, and so we need that second answer. Okay, so Peter thinks they were liable. Lily thinks not liable. We'll reveal who is correct shortly. And we're going for that second one as well. So the doctor was classed as an, we need a phrase there. Okay, so Peter thinks liable because the doctor was an employee. Yeah, accessory to the box, Elizabeth. I'm not sure what that means. But tutor to you, independent contractor mentioned earlier. Jim, thank you. Okay, can we reveal our answer? So the case of Barclays Bank plc and various claimants held that the bank were not vicariously liable because the doctor was classed as an independent contractor. So as pointed out earlier, this is a key case. You should be trying to use this and Morrison's 2020 case to illustrate your current knowledge and to ensure indeed the rules have changed too in certain moments and certain scenarios. Okay, next one please, Jim. Thank you. So in the case of Cox and Ministry of Justice, the prison were blank because the prisoner was doing a role blank and blank. So we need to fill in those two phrases again. So once again, in the case of Cox and Ministry of Justice, the prison were blank because the prisoner was doing a role blank. So Sarah went through this earlier with you. Let's see what you can remember either from that or indeed your studies on vicarious liability. So we've got Lily coming in with liable role of an employee. Okay, thank you for that one, Lily. Would anyone else like to take a educated guess on these particular blanks? Okay, so we're looking for maybe Peter and Elizabeth to come in with some responses. Okay, and we will reveal our answers now. Okay, so in the case of Cox and Ministry of Justice, the prison were vicariously liable because the prisoner was doing a role akin to employment. Okay, thank you, Peter, for your response. Okay, slide. And the final one of this challenge. In the case of Mohammed and Morrison's were blank because his actions were blank to his employment. So a little more complex now. Now this is something, yes, the last one. This is something we just went through before. Mohammed and Morrison's were blank because his actions were blank to his employment. So we can just pop in what we think that response is. And once again, if you come into this at another time, please be sure to pause and try to fill in the blanks before revealing the answer. You can give yourself as much time as you need if you're doing it that way, or as little time as you need if you wish to challenge yourself. So Peter, Lily, Elizabeth, do we have any responses? So we've got Elizabeth coming with liable. Okay, Lily thinks they're liable too. Okay, let's see what the answers are then. So in the case of Morrison's, in the case of Mohammed and Morrison's were vicariously liable because his actions were closely connected to his employment. So the defendant's actions where the assault were closely connected, even though it was a criminal act. Okay, thank you, Peter. Thank you, Lily. Thank you, Elizabeth. We now have one final challenge for you to end this session, and that is to do this. We need you to list as many cases as you can for vicarious liability. You have 30 seconds. Now, you can get your typing fingers at the ready. If you're doing this at home, you can, of course, write as many down and challenge yourself. Okay, we're about to start in 3, 2, 1, 30 seconds. Okay, so as many cases as you can. Pop them into the chat box. Okay, a couple of seconds. Okay, we hang on to see if they're coming in. So we're looking for as many cases as possible. Okay, not yet in the chat box. So Lily. So Barclays Bank and various claimants, well done. Cox and Ministry of Justice, well done. Mohammed, excellent stuff. So they're ones we've done recently. Okay, so we could have had a number of different cases. We've looked at the most recent cases, Barclays Bank and indeed Morrison's and various claimants too. In particular, we could have a Lister in Helsey Hall, could have had matters even century insurance. So there's ready mixed concrete. Indeed, that is a case used to identify employment. Yeah, we've got some of the similar cases from Elizabeth as well. Well done. Okay, thank you very much for that, folks.
Superb stuff. That session just goes to show how important those cases are, isn't it? In terms of,
Indeed.
I don't know, is there an easy way to remember those cases? On the Morrison's one, 2016, I was trying to imagine a fight taking place at a Morrison's petrol station.
Petrol station, indeed. Yeah, indeed, that's exactly what happened, isn't it?
And I
I
reckon I can remember the milk float one because I can imagine a kid like I used to.
Yeah,
driving
perhaps
around in
I
milk float.
suppose.
What's the way
Well,
to do it?
listen,
How do you
I
do it?
suppose drawing diagrams, I always find it useful if you do get PowerPoints for students to draw diagrams to help them remember. One
Flashcards
way
are
for
always
me,
really good at that. I always recommend flashcards to my students. So having
absolutely.
the principal on one side of the flashcard and the name on the other, drawing a little picture if you're quite artistic or creative, as Jim said, or printing one off and sticking it onto your flashcards would be quite good too.
And even just doing card sorts with them, so you could do images, you could do legal principles, cases, and maybe mix and match and see if it matches up with your notes, certainly. And then the next step to that would try to be, what do they prove? So is it close to employment? Is it proving employment? And that's one way of doing this. I'm going to do that you could do for any particular tort, which is quite case heavy.
Maybe we do a mega set of big reveals on a PowerPoint that they appear at random and just keep testing
Indeed.
yourself again and again and again. Must be possible.
Yes,
I
absolutely.
think the
Yeah,
facts
that's what we
definitely
could
help,
do.
don't they? If you can remember the facts, it helps you to remember the outcome,
Yes, without a doubt, yes.
why the person was liable or not.
Well, talking of
Indeed.
big cases, I think it's Rylands versus Fletcher, isn't it, next week?
It is. We've
Wow.
got Liz and Rabina next week.
Fantastic. And that's our last live session before half term. We'll take a break for a week or two and then come back and we'll be announcing the topics for post half term up to Christmas very soon. But yeah, next week, 6:30 on a Tuesday for some A-level law revision. A massive thank. Hopefully you enjoyed the session. A massive thanks to Sarah and to Dan for putting the session together and for delivering it tonight. If you've enjoyed it either live or on replay, please give the session a thumbs up. It makes a big difference to us and also helps YouTube suggest this type of support for other law students. So that's much appreciated. Don't forget, if you go to tutor2.net/live and then choose the law drop downs, you can see what's coming up, but also go back over previous sessions. Dan and Rabina and Sarah and the team have done lots of these sessions already in 2021, not just this term, but go back earlier in the year. I'm sure there'll be something there for you that's going to be really useful if you're getting ready, revising for some tests or assignments or mocks coming up at some stage. So take a look at that resource for you. And please spread the word. Let your fellow students know about this regular slot, 6:30 on a Tuesday, and hopefully we'll see you all again next week. So from all three of us, cheers and we'll see you later.
Thank you.
Bye, guys.